We're going to start right now. Thank you.
Well, good afternoon, everybody. It is my honor to welcome you here to this beautiful space, St. Mark United Methodist Church. I'm Reverend Josh Noblitt, and along with my colleague, Reverend Dana Everhart, we welcome you to this important conversation. I want to introduce Sean Young, who is the legal director for the American Civil Liberties Union of Georgia, to give us a breakdown about this important Supreme Court decision. Sean.
Morning. My name is Sean Young, and I'm the legal director of the ACLU of Georgia. This morning, the Supreme Court issued a decision in Fulton versus the City of Philadelphia, addressing whether Philadelphia, which seeks to protect LGBTQ people from discrimination, could terminate a contract with a foster care agency because of the agency's refusal to certify same-sex foster parents. In an exceedingly narrow decision, the court ruled that Philadelphia could not terminate the contract. But the important takeaway is this: the court did not rule that all private contractors with the government always have a license to discriminate against LGBTQ people. Instead, the ruling was based on the very unique terms of Philadelphia's standard foster care contract. While the contract prohibited LGBTQ discrimination, its fatal flaw was that it nonetheless allowed for exemptions to that very policy. Under the Free Exercise of Religion Clause of the First Amendment, individuals are not entitled to religious exemptions from, quote, neutral and generally applicable laws. Many non-discrimination laws are neutral and generally applicable. So for example, if there's a law forbidding racial discrimination in public accommodations, which there is, a restaurant cannot refuse to serve Black customers because of the restaurant owner's religious beliefs. However, in this unique case, the Supreme Court ruled that while the current version of Philadelphia's standard foster care contract prohibited discrimination against LGBTQ people, the contract nonetheless allowed foster care agencies to get exemptions from this non-discrimination clause. And because Philadelphia's contract allowed these exemptions, it was not, quote unquote, neutral and generally applicable. And when a government's policy is not neutral or generally applicable, the government has to have a very good reason to deny a religious exemption. In this case, the court reaffirmed that Philadelphia had a weighty interest in ensuring that, quote, gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth, unquote. But because Philadelphia nonetheless allowed other agencies to seek exemptions from that non-discrimination policy, Philadelphia's reason for terminating the contract with this agency was not good enough. And that is why the foster care agency was entitled to a contract. The court left the door open to Philadelphia revising its standard foster care agency contract to prohibit LGBTQ discrimination across the board. And importantly, the court did not say whether an agency is entitled to a religious exemption when a non-discrimination law applies across the board. Nothing in today's decision prevents Georgia or any Georgia municipality from protecting LGBTQ people from discrimination. The ACLU of Georgia will keep making the case for equal treatment of LGBTQ people until equal opportunity is the norm and the law in the state of Georgia. Thank you.
Thank you, Sean. I'm Jeff Graham. I'm the Executive Director at Georgia Equality. And certainly, I am very disappointed in today's ruling. We feel that in all instances of adoption and foster care, we should look at first and foremost what is in the interest of the child and what is clearly in the best interest of any child in the adoption or foster system is to have a loving home regardless of the sexual orientation or gender identity of the parent or parents involved. And there will be some conservative voices who will claim that this is a win. However, in this instance, it was a very narrow ruling. I think it's important that we all remember this. This was an extremely narrow ruling in this one instance. We hope it does not have broad application, but it would say to conservative voices out there that perhaps the First Amendment does work, that there is not a need for additional legislation that would open up the doors for a license to discriminate broadly against members of the LGBT community or others. We've seen the dangers that these broad religious exemption laws pose in other states and across the country. So that while there is no additional legislation that is needed to protect people of faith, this clearly shows the need to pass additional legislation on the local level, the state level, and the federal level that will clearly outline that discrimination in all forms is wrong, especially discrimination against members of the LGBT community. That's why on a federal level, we need the Equality Act that is currently sitting before the US Senate. We need to re-engage a strong conversation of broad-based civil rights protections for all people here in Georgia, one of only 3 states that does not have such protections now. And we need to continue our push on the municipal level so that more cities and counties join the 12 already here in Georgia that offer these clear protections, not just for members of the LGBT community, but for immigrants, for people of color, for women, for veterans, and yes, for people of faith. Those are the values we can all get behind. Those are the values we need to push forward today and into the future. I'd now like to turn it back over to Reverend Noblitt for some final reflections from the faith perspective.
Thank you, Sean and Jeff. Just a couple of things that I wanted to add is that what we know is that LGBTQ folks make amazing parents, partly because they have to be more mindful about creating a home and thinking through the adoption or surrogacy process or the foster care process to create a home that is a loving, wonderful space for a child to grow up in. We see this in our own congregation. We have over 75% of our church members are a part of the LGBTQ community, but not just our congregation, but other congregations in Atlanta, across the city, mosques, synagogues, other houses of worship have LGBTQ folks that are amazing parents and doing amazing work. So I want to say that. The other thing I want to say is that it is a false choice to suggest that either one supports LGBTQIA equality or supports their religious beliefs. LGBTQ folks are people of faith as well. And I affirm this, the conversation that we've had today in that this was a narrow ruling, but that more work needs to be done on all levels of government to continue to create a world, a country, a city where everybody is welcome, everybody is included, everybody has the ability to create the families that they want to create, to raise children in a way that is affirming and holistic and happy. So we want to thank you for joining us today here at St. Mark, and we'll be available for any question and answers later in the day.
The one question in the chat for Jeff from Tamar Hallerman at the AJC. Tamar writes, there have been a few bills introduced in the General Assembly over the years regarding adoption cases turning down LGBTQ people. How concerned are you that those could see new life because of this ruling?
Well, I am always concerned that we could see efforts to further discriminate, specifically against LGBT folks, and especially within the adoption and foster care system here in Georgia. That's one of our chief concerns. That's also why I think it's important that we make sure that people understand the important nuance of this ruling. Some will say that this is a broad ruling that gives broad latitude to discriminate against folks and shut some people out of the system. Our attorneys would argue that that is not the case. In fact, if you really look at the ruling, this is a ruling that in some ways is similar to the Masterpiece Cake ruling of a couple of years ago. It does not strike down non-discrimination protections. It just says that where there is a religious exemption, that the government has a duty to really look at what people of faith are saying before they make a decision. That's a common sense approach to this. I don't necessarily agree again with this ruling, but we've got to look at the broader picture. And that is that here in Georgia, we continue to have far too many children in the foster care system. It continues to be a challenge for so many couples to be able to adopt or serve as foster parents, especially those that are in same-sex relationships or identify as members of the LGBT community. We need to make sure that our policies encourage all prospective parents to come forward, and we need to make sure that we constantly look at what is in the best interest of the child. And the best interest of the child is clearly being in a loving home regardless of the sexual orientation or gender identity of the parents. That's the message that I hope that we can take away from here. And I hope that we can avoid the sort of divisive debates down at the legislature that we've experienced on this issue in the past. We now would welcome any further questions from members of the media that may be joining us live on Facebook. And again, all three speakers will be available for additional questions later in the afternoon. Thank you so much for joining us.
All right, Dana, we can